I thank the majority leader for moving this motion. Now, Mr. Speaker, before I go into the substance of this bill and the report, some members of this committee were the driving force behind the report. In fact, a lot of times you hear the name of our chair, Senator Okongo Omugeni, the senior counsel, Senator Mutula Kilonzo, and Honorable Otiende. I want to confirm to this House that this report was signed by the majority members of this committee. In fact, if you look at the initial page, the introductory page, forward by the chairpersons, it is signed by Honorable Clement Muturi Kigano with Honorable Eric Okongo Omugeni, Senior Counsel. And if you go to the signatories which are found on the Roman 6, then you find all the names of the members who signed the report. It was generally a unanimous report, save for the abstention of Honorable Kangata, Senator Kangata, and the distinguished member of the senator from Nairobi. And a notion should not be passed out there that there are certain members of these two committees that were driving that committee in a certain direction. And if you look at the recommendation, sometimes I don't know where some people put their brains. Yeah, they lock their brains somewhere in a toilet and just speak. Because there are people out there who are telling us, to support this report. To support this report as if there is anybody saying something different. If you look at the last page of this report, the committee, even Senator Sakaja, who had a minority report, and Senator Kangata, who abstained, there is no contrary recommendation. The recommendation is that the amendment bill should be passed. So those who are saying this and that outside there, they have never looked at this report, and they are trying to find fault where there is no fault. The second issue that I think is more crucial for us is those who are saying that the role of Parliament is ceremonial, or that the role of Parliament is that of, rubber stamping. Indeed, if your role was to rubber stamp, you would need more ink than brains. Because when you rubber stamp so many times, you may run out of ink. This Constitution, it is clear we have certain responsibilities. And it starts from Article 1 of the Constitution. People have not distinguished the various roles of Parliament. And people think that Parliament is just a legislature. According to this Constitution, Parliament is more than a legislature. And that is found in Article 1, sub-Article 2, which says the people may exercise their sovereign power either directly or through their democratically elected representative. That is distinguished with the powers, legislative powers, which is found in sub-Article 3. And I want really to dwell on the significance of this issue. It is very important. If you look at the articles dealing with the powers of Parliament, just in case people forget, and at one time we debated this, why this provision was there in the Constitution. Role of Parliament. And you find it in no other provision in the Constitution. Sub-Article 3, Parliament, Sub-Article 4, Parliament shall protect this Constitution and protect the democratic governance of the Republic. The protection of this Constitution, and when this Constitution is talking about this Constitution, it means it is something to be hallowed, it is something of value, and it means when you want to change it, you have got to think about what you are trying to do before you proceed to amend it, because it has got certain foundational values. And this thing that I'm talking to you about, honorable members, can find fortitude in the fact that all the organs, except the IBC, which deal with this bill, are through elected representatives. One, the county assemblies. Second, parliament. Third, if there's no referendum, is the president, because it's an elected representative. You will not find the name of a judge there. You will not find the name of any chairman of a commission. It is parliament, it's county assemblies, it's the president. And the most significant thing, and that is why Article 1, Sub-Article 2 is important, that it is our role to oversight and discuss and consider any policy issues that the Republic is considering. Even a private citizen, if he reaches out to the executive or any arm of government, we have a role to play to examine policy issues as a parliament on behalf of the people. And the significance of what I'm saying is this, Mr. Speaker, if you bear with me, how this process starts. It starts as a popular suggestion, which may be then formulated as a draft bill. Now, you'll find throughout, when it goes to the Independent Electoral Commission, what you're dealing with is a draft bill. Why is it a draft bill? I'll point it to you, Mr. Speaker, why it is, they're the ones dealing with the draft bill. When it goes to the county assembly, according to the Constitution, they're dealing with a draft bill. They are not dealing with a bill. The moment the counties, 24, have passed the draft bill, when it comes to parliament, it becomes a bill. It becomes a bill. And it is only parliament that then can pass or reject the bill. That is a matter of significance. And why is it, Mr. Speaker, a matter of significance? I want to take you to another article of the Constitution which is very critical. Parliament, this is Sub-Article 94, Sub-Article 3. Parliament may consider and pass amendments to this Constitution and alter county boundaries as provided in this Constitution. You know, that is a substantive provision in the Constitution. Parliament may amend. The president can't. The county assembly can't. The courts can't. But there is this provision, which is not for cosmetic value, in very clear words, that Parliament may consider and pass amendments to this Constitution. And I'll address you on this issue because I think it's significant to go through this. Why promote protect the Constitution? I think when we were in that committee, our committee on the Constitution, we had a discussion. Why does the Constitution need protection? It is important why this document itself says Parliament should protect this Constitution. No other organ of government is given that authority or power to protect the Constitution. I know the president is supposed to safeguard and comply by the Constitution generally, but the role of protecting the Constitution, that's the role of Parliament. Now, so that when a bill comes to you, and I think this has been debated in South Africa many times, when a bill comes to you, even if it's a constitutional bill, Parliament will consider the foundational values that are contained in the preamble of the Constitution and that are contained in Article, the construct of the Republic, which is Chapter 1 and 2. You consider those foundational values as a protector of the Constitution. And this Constitution is telling you in the preamble that the people of this country made this Constitution in the recital to honor those who heroically struggled to bring freedom and justice to our land. There are people who died for this Constitution to be enacted over the years. So this Constitution is reminding you, before you amend it, think that there are some people who died for it. So you cannot play around with it. We cannot play around with it. And there have been members of this assembly, or rather parliament, the National Assembly, who died in the protection of this Constitution. And we must remember them every time we want to change the law of the land, that they struggled for us to have this Constitution. And we cannot just play around it anytime that we want to change it. There must be good reason. And then they are saying in the foundational values, which are recited in the preamble, that we are recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The same foundational values are found in Article 10 of the Constitution. So, Mr. Speaker, I want to convince members that your role today and that of the National Assembly, it is not a ceremonial role. It is not a ceremonial role. And we are not here to rubber stamp. We are here to consider, like Article 94 of the Constitution is saying, we consider and pass. The Constitution doesn't just say pass. It says you consider and pass. So there must be evidence for posterity that you actually considered. And they can read the reasons why we made up our mind to change or to amend the Constitution as by law required. So this Article 94 is very critical, and the articles that I've spelled out to honorable members in the procedure for amending the Constitution through a popular initiative. Now, having said that, the committee went through a lot of discussion. And in this report, where certain observations were made, this committee gave solutions. It was not just a report hanging there without giving you solutions. They were telling you, the committee, that you should pass this bill, and where they found challenges, they told us how to address those challenges, which deals with issues like public participation, with the issue of the schedule that created this special category of constituencies. They considered the question of revenue as provided in Article 203. So in all their observations and recommendations, if I may put it that way, they are giving you an answer and a solution of what to do. And that's why, Mr. Speaker, seconding this bill, because the report gives us a way forward. Now, my colleague, the majority leader, has spoken to a lot of issues, almost clause by clause, and it may not be appropriate for me to take a similar trajectory and proceed by analyzing each and every clause. But I think for purposes of seconding this bill, I will make some observations both in the bill and also in the report. And some of the recommendations in the report or observations in the report are on matters which are really consequential upon amendment of the Constitution. The majority leader said now the executive partly is going to come to Parliament, and they have been given a different title that the one that exists in the Constitution, which is the creation of the positions of cabinet ministers as opposed to cabinet secretaries. And the amendment deals with amendments of those provisions, although some were left out, on the question that dealt with cabinet ministers as opposed to cabinet ministers, ministers as opposed to cabinet secretaries. They also made recommendations that the procedure for introducing a bill of this nature into Parliament, whether it should go through first, second reading, and third reading as the normal bills, or a bill brought under Article 256, that Parliament should come out with legislation and standing orders should be amended so that this matter is addressed, so that the procedure is clear. Because the argument was that in Article 257, the procedure is not set out. It simply talks about the question that we should pass the bill. Now, in Article, in regard to Article 203, which is found in Clause 50, on the question of allocation of revenue, remember we had a lot of debate on the issue of the allocation of revenue. And I think we should look at this very clearly, because the observations of the committee and that of the expert was the amendment may override the other parameters which are set out in Article 203. And it would be important that that issue is addressed, and probably the way to address it may be through consequential legislation. Mr. Speaker, there was also an amendment to the powers of the Judicial Service Commission, and I think this is one of the controversial ones. And I'm hoping that when we have gone to the referendum and passed this bill, enacted it through a referendum, that through judicial interpretation, we should be very, very hesitant to enforce that clause. Because what it means is that a judge may be suspended anytime without some kind of process, which goes against what is in the Constitution at the moment. It may actually lead to a clawback. Instead of enhancing the protection given to the judges, we may have taken away something if the interpretation, because I think through a harmonious interpretation of the Constitution, bringing harmony between provisions of the Constitution that may look inconsistent or conflicting, the overall principle which is contained in the Constitution itself, how to interpret the Constitution, that you must look at its values and objectives. And the objectives of this Constitution is to have an independent judiciary. So I think it's a matter we can deal with through legislation, consequential legislation, or through interpretation by the courts, because it touches on a very critical, construct of the independence of the judiciary. Now, the other issue which I think is critical, which now is very controversial, is the issue of the constituencies. And the committee delved into this issue, for long. There were very long debates. And I think it is in regard to this particular clause that we had probably the abstention or the minority report by Senator Sakaja. But all in all, this provision, the committee was saying, without amending other clauses of Article 89, which spells out how you create constituencies, that provision may be hanging on nothing and may mean nothing. That's what the committee was told. And it may be creating a parallel system of delimitation of constituencies, one which is constitutionalized and one which can change at any time. Again, I think if you read that part of the report, it is not left hanging. They tell you, the committee and the suggestion of the experts, that it actually may be much ado about nothing. Because on a proper construction of that provision, one would ask the question actually whether the constituencies have been created or not. And if you read that section properly, I think the debate should really be, is it a provision that is enforceable, or is it hanging in the air? And to me, that is the reason why I've come to the conclusion that we may not necessarily need to sever Schedule 2 or amend it, because the reasoning was, and I think the South African cases that were cited, that a schedule is part of the Constitution. You cannot amend a schedule thinking that different rules apply. The schedule is, properly speaking, part of the Constitution. And therefore, severing it offers many challenges. But I've heard the cry out there. I mean, the report by the Kenya National Bureau of Statistics, for example, they're saying, if you look at the demographics and the parameters, a place like Itui should have had a constituency. And that is the expert saying it. It is not some busybody who was saying. They're saying like Meru should have gotten a constituency. They are saying Kisi should have gotten a constituency, and Bungoma. We should have those constituencies on those areas if you are using the parameters set out in the Constitution. And I know in my backyard, there's a lot of noise coming from, not noise, legitimate concerns from the people of Nyatike, the people of Karachonyo, the people of Homa Bay, the people of Siaya, and in the neighborhood, I know people of Busia, and of course I've talked about Kisi. And then also by all accounts, Kakamega is one of the biggest counties by population, even by the number of constituencies they have now. So explaining how Kakamega was getting 2 constituencies is a bit of a problem if you're using a scientific method. And others are getting 5, others are getting 4, which they deserve. My position is that, they should not be taken away if they are deserved. But if you're using a scientific process, which has been demonstrated by the Kenya National Bureau of Statistics, and IEBC told us that actually they work with the Kenya National Bureau of Statistics for purposes of boundaries and delimitations. There is a question mark there. And at the end of the day, and which I want to persuade our members here, that the severance of that schedule or amendment of that schedule may not necessarily be the answer. It will not help. So it is better to pass this report as it is, because I've looked at so many reports, and I think this is one of the reports that I can say, a lot of brain work went into it. A lot of experts A lot of our good people, distinguished senators and members of the National Assembly, they put their mind in this report. And if you look at the attendances, people were so regular and constant in their attendance, virtually or physically. Even when they were abroad, you know, they were taking part in the deliberations. And of course, if you say you want to take some constituencies from a place like Nairobi, then the argument about population, can we deny them? Because one of the parameters is population. So it's a debate that is very difficult to win. You will go on, and people will raise issue with the delimitation of constituencies, even if they are fair and just. The other thing that, of course, which was protected was the existing constituencies, plus the protected constituencies. Because you may find an area that maybe overall they deserve a new constituency, but within it, they have got protected constituencies, which actually, if you use the scientific process and the parameters set out in the Constitution, you may find a county that may lose 2 constituencies. And they're there, and quite a number, in Central, in Western, in Nyanza. They're all over. And Makueni, in Lamu. Lamu, if you use those parameters strictly, Lamu would end up being a 1 constituency county. So, and then, Mr. Speaker, there is a question on North Horr. North Horr is so huge. It's so huge. I think it's bigger than Nyanza twice. And it is 1 constituency. Yeah. And yet, every time we have a review, they don't get it. They don't get it. And yet they are protected constituencies. Why North Horr cannot become a protected constituency using the same criteria which made it possible for others to be protected is beyond comprehension. You have Wajir, where there's a very legitimate concern about another 1 constituency or 2. You have Ijara in Garissa. Yeah, so all over the Republic, there are people who deserve to have these constituencies. So that depending on the availability of the number of constituencies, we may not be able to resolve that question. And we are now resolving, because we have created now we are going to have in the National Assembly 360 members of parliament. And if you don't get the gender balance, which happily will be attained in the Senate, you have to give a top-up, gender top-up. So we are going to have a National Assembly which has got 500,000. I mean, 500. 500 members of parliament. I think in that parliament, people are going to be talking for 1 minute. Yeah. Yeah. And then in the Senate, because now we're going to be about 100, your usual 5 minutes will come 3 minutes. Yeah. So there are burdens that, there are burdens which have been created. But those burdens, like the one on gender, is a constitutional requirement, is one of the objectives of the Constitution. And we have tried over the years to address that question of gender, but without success. So one of the things that I think we can say about this bill is that it has addressed that question, and at the same time, it has a sunset clause, which means that they are not going to be there forever. Or if you reach a situation like in the Scandinavia, where parliament's membership is in favor of the women as against men, we may reverse the role, and you have more nominated members of Parliament or the Senate who are men. Mr. Speaker, there's one provision in this Constitution which describes the character of society that we want to create. It is a new provision. It's going to be a new provision in the Constitution. And I think it is so fundamental. Remember, Nyerere described Kenya as a man-eat-man society. And we have not changed that character, actually. We are truly man-eat-man. Kenya is the only place you can walk through a government, no, not walk through, just walk near, past. You know, even a pub, you cannot walk past and you're called for a drink. But in Kenya, for some reason, you can walk near a government organization and walk out with a 3 billion shilling tender. So really, we have not really changed the definition of a man-eat-man society as propagated by the late Mwalimu Nyerere. So this clause 11A, which is right on the first page of the amendment bill, that talks about the economy and shared prosperity. I hope it's not just there to please ourselves. And it says this constitution recognizes the need for an economic system that provides equitable opportunities for all the people of Kenya to benefit from economic growth in a comprehensive, fair, and sustainable manner. Now, I wonder whether we'll be able to achieve that. In the last 2 months, if you look at the appointments that have been made, I don't know whether we are going to that direction. No. Because it's saying a manner which is giving equitable opportunities. So we should look at every institution and see whether we are creating the face of Kenya, be it in the judiciary or in the public service or in the security systems. This objective is one, I think that if we committed ourselves to it, and I cannot read the other enabling provisions in this clause because it will take long, but if this can become a face of the country we call Kenya, which is fairer than we have had it, then we would have made big strides. And there's another clause there about regional integration and cohesion, which I think is contemplating even a confederation. If you wanted to create a confederation in the region or have a federation, then we'll be having an underpinning provisions in the constitutions that makes it possible. Now, the other big achievement through this BBI document was that the Bill of Rights was never touched. Me as a practitioner of law, and we know today we had that experience of one of our own being arrested in a manner that does not reflect what type of society we want to be. That even if you are arrested, you must be arrested in dignity, because there's a constitution which sets out that human dignity must be protected. So we have all these clauses about the Bill of Rights, which are there when we want to speak well of ourselves, but when we examine how we apply them, then it looks like we are trying to create a very different kind of society. But Article 31 of the Constitution is to be amended by expanding the provisions dealing with privacy and to have personal data infringed. We are entering an age of a digital revolution and online communications and so on. So I think this is a very good provision to have in this bill. And the majority leader also talked about the question of speedy investigations on matters dealing with the corruption. Now, clause 18 about responsibilities of citizen, I think they're well placed, but they should never be used to create additional burdens on the people of Kenya, because these are just broad responsibilities They are not a legal obligation. They're not set out in terms of an obligation. So that if a taxman requires you to make your tax returns, he should not rely on that article dealing with the responsibilities of citizenship. And I think, Mr. Speaker, now that we are bringing the executive back to the House, and more particularly the National Assembly, I think this is good for our type of democracy, because you have seen how difficult it is to have this kind of separation of powers that we had. The executive feels that they are distinct from Parliament, and when they are summoned, they hesitate to come before Parliament. But I know Honorable Wetangula and myself and others who have grown in that system, and the leader of majority, that when ministers are in the House, they tend to be more reflective about how they relate, not only to members, but also to business in the Assembly. And I think bringing the executive back to the Assembly or to Parliament is a good thing, absolutely a good thing. And Mr. Speaker, the only thing that I hope that when they begin to have ex-official members also, who are ministers who are ex-official members of Parliament, that does not bring a big number of non-elected members, because part of being a minister in a National Assembly is that you feel your accountability to the head of state and the head of government, but also accountability to the people who elected you. And if you have a person who is not elected and is a member of the cabinet like we have now, they just become part of the bureaucracy. They cannot speak for you, they cannot speak for anyone. And I think that is a good thing to do. But Mr. Speaker, all this now depends on how we manage our affairs. And this is about institutions. And institutions work when people respect what is required of those institutions. When we as leaders do not we only want to hear what, we want to be told what we want to hear or what we want to know, and not what you don't want to hear or what you need to know. That sometimes is the beginning of autocracy. And as a parliament and as a people, I think this is how we get it wrong sometimes. Because slowly you can have dictatorship stepping in because somebody is surrounded by advisors and officials who are only keen in telling the leader what they want to hear or what they want to know. But I think the responsibility is first to tell the people the truth, and whoever is in authority to be told the truth. If that does not happen, then willy-nilly autocracy will step in, and at great cost and disadvantage. And Mr. Speaker, finally, I think in the future, we may want to think about revisiting the role of the Senate. I think this was not very well handled, but the role of the Senate should be enhanced if the Senate is not in the executive, as it is going to be. There's some hesitance, official or otherwise, to try and make the Senate as weak as possible, and for the Senate to be disregarded. And all over the world, even where the Senate does not have powers, there's a time when we made a trip to France and they were telling us, on paper, the Senate in France is a much weaker chamber of the bicameral system they have there. But they say when they have an important legislation, a very complicated legislation, or a complicated issue, they would rather it to be dealt with the Senate, give the Senate more time to deal with. And they said over time, the Senate has assumed quite a number of responsibilities, some of which is unwritten. And because now the government is going to sit in the National Assembly, the most effective way of putting that government to account is by having a strong Senate. And I think the position of senators should be enhanced even as we deal with governments and with officials and with bureaucracies. That I think was not quite well done, but that's not to say that some vetting powers which were not there originally have not been placed before the Senate. The Salaries and Remuneration Commission, again, the role of Parliament has been to some extent compromised, which will make that body more accountable to the executive rather than to Parliament and other institutions which are important, like the independent commissions. I also hope that when the BBI thing when the bill goes through, that the National Assembly will not use it to now cry for more funds. Because now, you know, the ward fund is 5% of the funds that go to the counties. And it'll just be competition for funds. But I think the more we do that, the less the role of the Senate and Parliament is going to be undermined. So, Mr. Speaker, as we had agreed, you know, I don't have to take all the time, but I want to say without fear of contradiction, because I must repeat this because this thing has been said again and again, that our role is simply ceremonial. And I think the provisions I've gone through answers that question very clearly. And when we pass this report, is on the basis of the process that we undertook, including public participation, and the bill for the first time is edified by being passed through Parliament, because all through it was a draft bill. But now what we are going to pass is a bill that now can go to the people for enactment. With so many remarks, Mr. Speaker, I beg to second and support. Thank you.